thank you for joining this free webinar today. Basically, what I thought we would do is just have a forum where we can discuss the most common questions that both I and actually myself and all the attorneys in my office have been getting. So we put together a list of them. If you have something that you want to add to, please put in a message and I will do my best to respond. So I'm assuming for this call, for purposes of this call, I'm just going to assume that none of the people are subject to a collective bargaining agreement. If you are subject to a collective bargaining agreement, please, post your question, because the information I'm going to provide really does not apply to union employees or anyone subject to a collective bargaining agreement. So one of the questions that I've most gotten is, are there limitations on how much we can reduce salaries and hourly pay rates at this time? One of the creative solutions for managing cash flow has been to change employee compensation. There are limitations. Of course, the minimum wage needs to be complied with. But other than that, you can reduce salaries or hourly pay rates as long as it's in the future and you're not trying to do it retroactively. And just from recent experience, making sure that you're very clear if benefits have been changed, you need to notify the employees of that, or if they're not changed. Also, there's been some questions about, well, what will their rate be if they take the sick leave or if they take vacation? And once their pay rate is changed, that's the rate that applies during sick leave or vacation as well. I also received, this might be a more specific question, but a question about, are medical providers excluded from the expanded FMLA provisions and the new sick leave law? Medical providers can elect to be exempt. Medical providers are defined as doctors of medicine or osteopathy, podiatrists, dentists, psychologists, optometrists, chiropractors, nurse practitioners, midwives, clinical social workers, and physician's assistants. There is not, what's not included are home care health workers. You might be able to apply for an exemption, or other types of therapists like speech therapists or behavioral therapists. They do not seem to be included in that possible exemption. If you have a specific question about that, though, please let me know. How to deal with employees that have work but decide it's not safe for them to go to clients. So you have some choices here. I mean, right now, the federal FMLA expansion and the sick leave, they're not in effect. So they go into effect April 2nd. So if you really are concerned about cash flow, you might have to make some decisions now. At this point, unless your policies say otherwise, you probably do not have to give them paid leave. But you might want to, and you certainly will have to give them the paid leave once the sick leave goes into effect and the expansion goes into effect. So I think you have to be mindful of that when you're thinking about that. And if an employee says that they don't want to come in and they're saying it's a safety issue, and there could be OSHA laws that apply, there could be retaliation claims that apply. So you really want to be cautious. If somebody says that they are scared or they don't feel comfortable going in or they don't feel it's safe to go in to continue to work right now, I would caution that we want to take that seriously and not require them to come into work, even if there is work available and even if you are an essential business. Somebody else asked, why hasn't the state or federal government addressed this as a mandate to insurance companies? The federal government has mandated that insurance companies provide coverage for COVID testing and COVID treatment. But I think the question really was, why isn't there a mandate that all that insurance should continue? I think, and it just hasn't been it just hasn't been put in any of the even proposed legislation so far. That's not to say it won't happen. There's certainly going to be additional federal funding that's going to be considered. So that could be something, and write your representatives, because that could be something to be considered. I don't think it's necessarily on the radar right now, because that was the other question. When can reductions in salaries or hourly pay take effect? You should give employees advance notice, as much notice as possible, but as long as they have some notice, it's fine, as long as they are employees at will. If you have employees who have contracts, you might have to consider some alternative methods. How many days of notice need to be provided? That's not really a requirement. The notice should be in writing, though, and it should be as much notice as you possibly can. You know, Illinois has passed the predictive work week schedule law, but that hasn't gone into effect yet. That goes into effect in July. So for now, there's no specific notice requirement. Once that goes into effect, that will change. And so if we are still, hopefully we will not be, but if we are still in a situation like this, then there might be different rules about what kind of notice you're going to be providing. People have also asked, are there different rules for staff who are hourly and staff who are salaried? Yes, to some extent. So if they're salaried and they're exempt, meaning they meet one of the FLSA exemptions of they're professional, they're an executive, or they have an administrative exemption, then, and you want to maintain that exemption, you do need to stay within the salary threshold. And also, if you're going to decide to do something like furlough, you should furlough for entire week periods, because an argument could be made that if they're not paid, if they work one day and they're not paid salary, then they are no longer an exempt employee. Now, depending on your business, maybe you don't care about that, because the exemption really is about access to overtime pay. But then you have to be very cautious when you return business to normal, that you make sure it's well documented that they are becoming a salaried exempt employee again. So for hourly, it's really critical that you just maintain at least minimum wage. And I'm saying for salary cuts, you know, you get the biggest bang at the top end of the compensation. But if you have a very large hourly compensated number of employees, then it can make a difference there as well. But think that the cuts there oftentimes have the biggest impact and hardship on the employees as well. And to some extent, with the new federal law that is going to go into effect, not the one that's going to go into effect on April 2nd, but the one that we're waiting for signature on, there should be an expansion of unemployment benefits, and you might even benefit the employee more by doing some furloughs or layoffs. So that's another question. What's the difference between a furlough and a layoff? A furlough is not really a legal term. A furlough is essentially a temporary layoff. There's an expectation that employees will be returning. As long as they're returned within a 6-month period, the WARN Act wouldn't apply. And it allows employees typically to keep their benefits going. Now, we have to make sure that you're checking with your benefits provider and looking at your benefits plans, making sure that if they need amendments, that they're being amended. But it is an option that helps protect employees from having to get COBRA, which is a significant expense. And we really don't want employees who are on unemployment having to pay also for COBRA, or having to spend all their money on COBRA if possible. As for salary cuts, I should also say, do the cuts have to be the same by percentage regardless of the type of work the staff do, or can they be grouped by groups and classes? The main thing here is you want to avoid any appearance even of discrimination. So it is best to keep them by groups or classes. You don't want to look like you've selected, you know, for example, older workers, or you've selected only a certain race, or only a certain religious, anybody who with any protected class. We certainly don't want to look like we're cherry picking protected classes here. So from that perspective, keep them as uniform as possible. Next question is, does it benefit us to cut salaries instead of limit hours so obligation for PTO is reduced? It depends on the policy. If the PTO is based on an average over the week, then cutting hours probably has the same effect on the PTO as cutting salaries. So we really need to look at your specific policies to have a good answer to that question, but both are options. You can cut hours and cut salaries. The thing is, though, with salaried exempt employees, when you're saying you're cutting hours, to maintain the exemption, you're saying you get paid per week. It doesn't matter what the hours are. So from that perspective, you might want to just cut the salary for salaried exempt employees. And can you limit the hours full-time employees work for a limited period without affecting their insurance benefits? That really depends on the specific plan that you have in place. And so we should ask your broker, and also typically we would consult with a benefits attorney who's an ERISA attorney. So if you have that specific question, contact me and I can certainly put you in touch with somebody who specifically handles benefits. If there are people we're considering firing, so this is for people that you already probably didn't want on board, is it better to fire them prior to reducing salaries across the board so they get a better payout from unemployment? This is very fact specific. If you're going to do layoffs, then I would say probably your first picks are going to be people who are already non-performers. But again, you want to be careful. We don't want to use this time to expose any businesses to a discrimination complaint either. Then if you drastically reduce someone's salary and they quit, do they still get unemployment? The standard for unemployment in Illinois is that you lost your income through no fault of your own. So if it's cut to the point that they're eligible for benefits, they might want to continue working and get the benefits, because if they quit, it's pretty likely that they would not get the benefits unless you decided out of the goodness of your heart not to contest the benefits application. And then how much do we have to pay into unemployment insurance? You've been paying into unemployment insurance, and so it's already been paid. But typically what happens is the next year your rate would increase based on how many people accessed the benefits in that year. It's unclear, but I think that the government is not going to apply that, or there's going to be some exceptions for that. So we'll have to see. That's the indication right now, is that there's going to be some government support to offset the unemployment insurance. And then what figure is used for the calculation of unemployment insurance contributions? In Illinois, the maximum unemployment benefit for someone without dependents is $471 a week. But the new federal stimulus package that is coming into effect is promising an additional $600 per week per employee who gets access to unemployment insurance. I don't know when that will go into effect, but if somebody is collecting unemployment insurance now, at a certain point, that amount will likely increase. And what's the extended deadline for tax filings? July 15th. I'm not a tax attorney, so I would still recommend that you consult your tax advisor about filing taxes, because one of the questions was, is the extended deadline going to be extended as well? Right now it hasn't been, but it could be. So the difference between a permanent layoff and a furlough, we talked a little bit about. So there is a difference in terms of a furlough is typically supposed to be temporary. If it's less than 6 months, then we can avoid the WARN Act. If you are considering a layoff and you're covered by either the federal WARN Act or the Illinois WARN Act, we should really be a little bit careful here, because under the WARN Act, under the federal WARN Act, you have to give 60 days advance notice to affected employees. And you also have to give notice to the government regarding that, the local and the federal government. For Illinois, Illinois has different triggering. They consider a mass layoff as a loss of 250 or more employees, it's regardless of percentage, or loss of 25 to 249 employees that constitute 33% of employees at that site. So it is a little bit different, but you still have to have that same notice period. There is an exception, natural disaster or unforeseeable business circumstances exemption. So this, it's a little bit uncertain, though, whether the pandemic, I would argue it does, but that doesn't mean it's the law, whether that would meet the exception. At a minimum, we could say unforeseeable business circumstances is more likely to apply. However, if it's found later, you could be found liable to pay out that money if it's found later that you were subject to the WARN Act and didn't comply. The next question is, does an employer have to pay employees on furlough or temporary layoff? So this is a really good question, because somebody recently also was asking me, if you do furlough the employees, do you have to pay the federal sick leave that goes into effect April 2nd? And the answer is also, it depends. So if you're furloughing employees and you're very clear that they cannot use sick leave during that time, and then maybe you're also clear that they can't use any PTO during that time, then they would not likely have access to it. Especially if they're getting unemployment benefits, then they wouldn't get access to, they can't get the double pay. Now, if you say that they can use sick leave and vacation leave to bridge them, then they will likely have access to the April 2nd, to the sick leave under the federal law beginning on April 2nd. So be very clear with employees. And if you're going to furlough them and you're letting them keep their benefits, be clear about how that's going to work, because in many, if not most cases, the employers that are saying employees can continue with their benefits are requiring the employee to continue paying the employee portion of the benefits. Sometimes we're saying that they can use the vacation pay to pay that employee portion, but you have to be very clear, because otherwise you can trigger other laws, and we want to avoid doing that as much as possible. So, and again, for furlough, if you're furloughing any salaried employees, just on the side of caution, it's best to do it for a full week rather than trying to do partial weeks, because there will be a lot of cleanup down the line if we do partial weeks and they are switched from exempt to non-exempt employees. So, and in fact, I've seen in some cases where we have done a bit of a furlough, where companies have either done a closure or some sort of furlough, that some employees have said, well, I'm just going to work a day because I know under the law you have to pay me salary. It is not that clear. If you want to keep the exemption under the Fair Labor Standards Act, yes, you have to pay them the full week. But if you're willing to forego that exemption right now and worry about it in the future when we can clean it up, then it's just not true. So even if you're an employee, you should be thinking that you can't really game the system by doing that, because your employer does have the option of saying, I don't care if you're exempt. I mean, I don't even have 80 hours for you to work right now. So, so work the day and we'll pay you for the day. Obviously, contract employees are more complicated. In most contracts do have a force majeure, beyond your control clause. And obviously those are going into effect a lot now. But even with an employee who has a contractual salary, there are oftentimes options such as furlough, because if the employee is not working, then they're not earning the money under the contract. So it's harder. You can't necessarily do a layoff of employees who have contracts. You still would have to comply with the notice requirements. but it's questionable if you have to do that if it's a temporary furlough. It really depends on the circumstances. Can an employer force employees to use paid time off, like vacation or personal days during any sort of, during a furlough? And yes, they generally can. Now, if they have a specific policy in their handbook, if you as an employer have a policy in your handbook that says you can't require them, which would be an interesting policy, then you'd have more limitations. But generally, you can do that. Most employers are allowing employees the option to choose, and that is a best practice for morale reasons. Ideally, we're all going to get back to work in a very short period of time and hopefully ramp up our businesses in really short periods of time. And you do want to have engaged employees who feel like we treated them the best way we possibly could during this time. So giving them some options is typically a good idea. And also there's, you might have noticed that a lot of larger companies have used this a little bit as a PR, the things that they're doing to support employees during this time. It's a PR opportunity. So does an employee need to accrue benefits like sick leave or vacation during a furlough? There's not really a legal requirement, but you should be very clear and when you're notifying furloughed employees that they will not be accruing vacation during this time. Now, we're pretty early in the year still. We're just ending the first quarter, so I'm not clear on whether or not their 401k could be affected. Certainly, they wouldn't be making contributions during that time, but is that time going to be counted? Is there going to be some way to offset that? I'm not sure. And I would ask a benefits attorney that. So if you have that specific question, I'm happy to reach out to a colleague who focuses on the area of law and get some clarity there. In the case of a permanent layoff, the employee is definitely going to have access to unemployment. I got a question too about, well, what if you have an employee who you feel like you could have terminated for cause a couple weeks ago, but you didn't? Will they still get unemployment? If you didn't terminate them at the time the cause occurred, then you probably don't have cause anymore. And I would really caution, even if you did have cause, the likelihood of the person interpreting some sort of wrongful conduct is pretty high in that situation. So I would be careful there. Oh, so now, sorry, I wasn't able to see the questions, but now I have a number of questions. So what support exists for 10 to 99 employees who work in an affected industry, such as aviation? Well, the support is coming out now. I know a lot of the aviation companies are making changes, or depending on potentially the loans from the government, or possibly doing certain furloughs. So there's some support that's going to come out through the stimulus, but I'm not really sure for 10 to 99 employees. I think they're going to have the companies are going to have the same access to the loans, the forgivable loans, or the other sort of federal funding. Now, if you're asking about the employee support, they're going to have the same access to unemployment benefits that other employees who are not going to be able to work are going to have. The next question, are you saying if we're contemplating layoffs that we need to do so before the deadline? Okay, I'm not necessarily saying that you need to do so before the deadline. If you don't have the cash flow, you can do so after the deadline. There are retaliation provisions, though, in the sick leave and the expanded FMLA law. And if it looks like you're doing so in response to that, that could be an issue. Now, if you truly don't have the cash flow, that's a different question. What are my thoughts on how 90% of the workforce applying to IDES is going to impact our experience rating in 2021? I do think that the government is not going to apply the same application of an increase in unemployment benefits, or if they do, it's going to be across the board, and it'll be based on how quickly the economy has rebounded. So right now I can't make any promises, but I certainly don't think that the extra $600 a week that the federal government is providing is going to have any impact. It's, what is the obligation for employers to satisfy employee sign-on bonuses if they were furloughed before the required amount of work days worked were satisfied? Well, I would need to see the specific language, but if the actual language says you must work X days, you must work 90 days, and then they're furloughed, they're not working those days. And so I think that you'd be in a good position to say it will not be paid until the requirements are met. But the requirements have to be very, very clear, because if they're not, it's going to be construed against the employer. I mean, contracts generally are construed against the drafter, but certainly they're going to be construed against an employer when you're talking about a bonus or something like that. And then, is group insurance coverage impacted? Somebody else asked, is group insurance coverage impacted by a layoff or furlough? Yeah, that's going to really depend on the specifics of your plan. And so this is the time to be calling your broker. And if your broker can't help you involving an ERISA attorney, we want to be careful with that, because violating the requirements of your plan can expose you to some pretty extensive future liability. So even if you're not going to address it right now, make sure it's on your radar that it needs to be fixed in short order. And I would prefer that it be addressed before making the decision. But if that's not possible, as soon as practical, then it should be addressed. And somebody else also asked, can you bring back employees if you do a furlough and you furlough everyone, or if you do a mass layoff or temporary layoff, can you bring people back in waves? And yes, you can. You can bring people back based on business needs. Again, though, you really need to be careful that you're not implicating discrimination laws when you're doing that. So it should really be based on the necessary experience and skills. So I'm going to talk a little bit about some creative things people have done that are their furloughs of sort, but what they're doing is like a 3-week on, 3-week off model, where they have one group of employees work for 3 weeks and the other group of employees getting unemployment benefits during that 3 weeks. And then they can come back. The people who are on unemployment benefits can work for 3 weeks. And they have to recertify. You have to recertify for unemployment benefits every week, even during the 3 weeks that you're working. But as long as the employee continues to call in and recertify every week, they won't have to reapply for benefits after the 3-week periods. So it's a way to keep people working. It's one of the creative ways I've seen to keep people working, but still save on payroll. It sounds like some people had to. So if you don't have access to the chat, you might have to exit and re-enter. I've just got notice that some people have had to do that. So I got the question, my company says it's an essential business, but doesn't do any of the work it says in the paperwork that we have to have with use to drive to work. I'm not sure what that question is. So somebody said, go into more detail about how we do that. I think they're asking about the schedule changes. Everything you do now should be in writing to the employees. So if we're going to implement this kind of more creative furlough where you have certain working days on, certain working days off, it is better. I've also seen people, I know a lot of hospitals in terms of trying to keep clean are doing 3-day on, 3-day off schedule. But it is probably better for the employee if you can do multiple weeks, like even if it's 1 week on, 1 week off, because then the employee would have access to the unemployment benefits during that time. Somebody's saying have to enter questions in Q&A. Chat does not. Yeah, I've not been getting the chat. The Q&A is the only thing that works for me too. So to go to apply the 3 week on or 1 week on or 2 weeks on, we would just have to make a determination and then send all the employees notice of it and be very clear about what the schedule is, whether their benefits will be affected. Also, I'm always saying you're not obligated to tell an employee that they have the right to apply for unemployment benefits, but I think it's a good idea and it will maintain the relationship as well. So having a very detailed notice about that. Then I got the question, if essential employee refuses to come to work and gets a doctor's note, can an employer terminate the employee? I mean, you can always terminate an employee, but you're really exposing yourself to some liability if somebody comes in with a doctor's note and then you terminate them. There could be potentially, based on how big you are, there could be an FMLA issue, there could be an ADA issue, or even under the Illinois Human Rights Act, there could be a perceived disability claim. So what I'm curious on the creative furloughs is what the W-2 tells IDES each week. So employees, with IDES, the employee has to certify for benefits. So each week, the employee will call in to certify for their benefits, and it's an automated system, and they have to say if they made any money that week. So the W-2 is going to have their total annual compensation, but they'll be able to say, and the company could be audited too. So if people are lying, it's going to come out. Then if you give employee more hours than worked, can you have them make up those hours later? I think you're saying if you pay them more hours than they actually work, can you have them make them up later? No, especially if they're hourly employees. If they're salaried, exempt employees, yes, you can do that. But if you're paying hourly employees, you cannot make them make up those hours later. No, because then they're worked hours. Are there forms to apply for the Families First Act benefits, and what are the documentation requirements? This is still a bit unclear. The Treasury Department has the authority to implement all of these benefits. I think you're asking not for the employee, but for the employer. For the employer, you're going to have to. We're going to have to wait for a little bit more clarity on that. So then, hold on. I want to make sure I get this question here. We're considered an essential business, but I'm concerned if I allow employees to work and they get sick, I'm liable. Okay. Yeah, a lot of people are concerned about that. It would be very hard for them to say, though, that it was because of you, especially because a lot of people are still going to the grocery store and leaving their homes. But you said, especially considering some of our employees are working only virtually, but some are working on job sites, construction. At this point, people are doing their best. Employers are doing their best to provide appropriate protection, like if you have masks or things like that. For employers that I've helped, a lot of times we're giving a disclosure and we're having employees essentially sign an acknowledgement that they're choosing to go to work during this time, because I'm not sure what the potential liability is if somebody does get sick. Now, if somebody gets sick and hopefully it's a more mild case, then there's probably very minimal liability. But if somebody gets sick and ends up in the hospital, we don't even know yet. One of my clients did tell me that they saw that some of the nursing home litigators, the plaintiff's attorneys, have been advertising that if your loved one gets COVID-19, has been diagnosed with COVID-19, to call them. So I'm sure that there are attorneys out there who are preparing for maybe class action or individual actions related to that sort of liability. So if you can get kind of an acknowledgement that this is what's, that we can't control the potential spread, then that's probably a good idea. Hold on one second. There's more questions. Have you heard of people having a hard time applying for unemployment? Yes. I mean, think about it, the employment system it's a bottleneck right now. And so I have heard, I've heard that it's impossible to call in. You have to do it online. I've heard that the system has crashed sometimes. So, I don't think that the state or the federal government is really prepared for all of this, but they should have access to the benefits once they can get through the actual application purposes. Can the Families First benefits be used and paid on an intermittent basis? Well, they're under the FMLA law. Yes, they can be used on an intermittent basis. So if you have an employee who says that both that employee and their spouse are required to work from home and their kids have no school and they have to switch off weeks, then I think that they will, because just normally under the FMLA, you can use intermittent FMLA. So yes, I think that they will be able to say, 1 week I want my 2/3 pay under the act, and the next week I will do my full work. So we have to be careful, and that's up to 10 weeks that they'll get it. The first 2 weeks are unpaid under that, except that once a sick leave goes into effect, really the first 2 weeks will be paid, and then the remaining weeks will be paid at 10 weeks will be paid at that 2/3 pay rate. Then if I want to pay more than hours worked, should I call that a bonus or something other than hourly wages? Yeah, that sounds nice. If you want to pay your employees more during this time than what they're actually working, I would at least document that you're doing it, even though you can't get a credit for it later. You might be getting a goodwill credit from your employees. So, but you don't have to document it as a bonus. I mean, you can still pay them for full hours and say, we're doing this. Just make sure that you're communicating it clearly and, also explaining to the employees that maybe it won't last. You're going to try and continue to do that for as long as possible, but that might not last. Another employee asked, we're in trucking, but don't do what they're telling. Also, we do not have any hand sanitizer or gloves. We see road drivers from all over the U.S., but have no protection. If you can get gloves and hand sanitizer, you should definitely do that. I'm not sure exactly what the question is, but if possible, to minimize exposure, you want to provide your drivers with some protection. And actually, if you email me separately, I might know some people who can get you hand sanitizer, because I know that was a problem and sold out for a lot of people. Can a 1099 person or subcontractor file for unemployment benefits? Yes, actually, starting April 2nd, when this law goes into effect for pretty much, I think, the first time, a 1099 person or subcontractor or anybody who's self-employed will also have access to the unemployment benefits. So that is something new that is under the Families First, the expansion of the, that's under the new act, the expansion of the unemployment benefits. So next, for businesses that are not essential industries, but are hearing from clients who are working on the front lines that they consider your business to be essential, and that they require help, and you have W-2s begging for work and volunteering to take on these requested visits. What do you advise? I mean, this is a difficult question, because right now there is a stay-at-home order, and there could be, now so far I've seen that they're not, issuing tickets or anything like that. But you potentially have liability if the employee ends up having some liability to do this. Now, maybe we could argue some service providers that are assisting essential businesses are getting exceptions. But if you're using the fact that you're helping helping clients who are on the front lines to also offer services beyond that, then I think you're going to have a risk. Now, if you're really helping the families of doctors, nurses, etc., then we probably have some argument that could be made. But I would be very cautious because I really don't know what the liability is going to be at this point. And somebody said, did you say we should have employees sign a disclosure of possible health risk if they come to work at their own risk? Sort of. We're not calling it that because but yes, it is. It's a disclosure or an acknowledgement. Yes. We're not asking them to sign a waiver, but something that at least says that they understand that we cannot guarantee that there will be no exposure, and that says what efforts you are taking to minimize risk. So, for example, deeper cleaning of your facilities, you want to note that, or if you're providing any sort of protective gear like face masks or hand sanitizer, you want to note that in the acknowledgement as well. And then it just helps because it shows that you're fully disclosing to employees that they have a choice here, because a lot of people do want to continue to work as much as possible, but we all have to balance that with the public safety issues. So yes, I am saying sign a disclosure, but be careful what it says, because you don't want to look like we're requiring employees to do something when you're really giving them an option. And I think it looks better as long as when you have some people who are taking the option of staying home and other people who are saying, I really want to work. And those are the people who are signing the acknowledgement. Now, we're only doing that for essential businesses too. So I have not done any sort of acknowledgement for a business that is not considered an essential business. So keep that in mind as well, because I'm not sure, it wasn't stated in the question whether or not it is an essential business. So. I'm trying to think. So those are the majority of the questions that I have gotten. If you have more questions, send them now, because otherwise we'll just end this in just a couple more minutes. Somebody else did ask if you can reduce salaries during furlough periods, and yes, you can. So you can do things in stages, in that you can say, right now we're gonna reduce salaries, then we're gonna furlough, or we're gonna furlough, and then when we bring you back, we're gonna temporarily reduce salaries. If you're doing it in that order, I would let people know as much as possible when that might end and how short that would be. And then somebody said, okay. I know there's not a new question. Some of these, you guys all are welcome to email too. I will give my email here right now in case you have more specific questions that I didn't answer. But thank you all. I think it's good for us all to see what other people are asking too. And then I will keep sending out updates as they come out. Oh, somebody just says, what if out of a small business, only 2 people get laid off and they've kept everyone else and you're feeling discriminated against? What should be my next steps? It depends what the basis for the discrimination is. Obviously, you should right away apply for unemployment benefits. And you should talk to somebody more specifically about why you think it's discriminatory and how people were selected. And this is why I'm warning the business owners that you have to be very careful that you're not even inadvertently discriminating against people when you're selecting who's going to be laid off and who's going to be kept. And then one other thing, in case others are new, you may want to explain your thanks. We practice employment law, so we're trying to stay on top of all of this. Obviously, right now it's rapidly changing, but I did provide my email. If you have questions, I will do my best to answer. All right. Thank you. Have a good one, and everybody stay safe and healthy. And this webinar will be recorded. It will be available on our website as well. So if you have anybody who you think needs to see it, just contact us. Okay. Thank you.